Hello and welcome to this talk on data breaches. I'm Tom Llewellyn, a partner in the commercial litigation team and a member of the data protection team here at Ashfords. I'm joined by David Varney, a partner in the commercial team and who's also a member of the data protection team here.
Hi all, thanks for joining us today.
I just want to remind everyone that this session is being recorded. We only have a 30-minute slot today and there's a lot to cover, as there always is. So we're unlikely to have time for questions at the end. However, if you have any, please do feel free to contact us direct using contact details in these slides, or they can be found on our website. So the focus of today is on the fundamentals of responding to a personal data breach. There are wider issues such as defending damages claims arising from data breaches or responding to ICO investigations, but they'll be the subject of another webinar. We'll start by looking at preventing breaches, then focus on identifying a data breach and the various steps that need to be considered when responding to it, including the breach risk analysis, notification and communication obligations, and the steps that you should take to rectify a breach. We'll consider data breaches as distinct from cyber attacks, which rightly necessitate additional considerations. As I'm sure you're aware, not all data breaches are cyber attacks. Human error, for example, sending out a letter to the wrong addressee, could result in a data breach but wouldn't be a cyber attack. Equally, not all cyber attacks are data breaches. One preliminary point to consider is, why do we need to respond properly to data breaches? The fact that you're all here listening to this webinar suggests that you are all well aware of the implications of not doing so. Notwithstanding, the primary driver is that organisations are subject to regulatory obligations in this regard, as well as being the right thing to do to safeguard the information you hold on data subjects. If you don't respond properly, then you can face a fine from the ICO, which can be up to 17.5 million or 4% of worldwide turnover. And the ICO's position is clear: no excuses. That's a quote from John Edwards, the Information Commissioner. Now, the context of that quote was about having the necessary technical and organisational measures in place, which typically mean training in cybersecurity, but it can also apply to post-breach measures, actions and plans. Failing to respond properly can also increase the potential damages claim you face from an affected data subject arising from a data breach. There is, unfortunately, a growing claims industry that will seek damages for any loss suffered as a result of data breaches. And even when there is no loss, they will try to claim significant and disproportionate costs and will seek to expose any failure when responding to a data breach. So the starting point is that organisations are required to have appropriate technical and organisational measures in place. This is set out in Article 32 of UK GDPR. There are no hard and fast rules in this regard. It's principles-based regulation requiring each organisation to undertake its own risk analysis. The higher the risk, the greater the level of security required. A point to consider and be aware of is it's not just from a technical and cybersecurity perspective. Be aware of the human element. There are some high-profile recent examples of individuals going rogue. For example, the Princess of Wales data breach at the London clinic, which and other similar examples, which are all cases of predominantly, nosy members of staff rather than a malicious attempt to steal personal data for another reason. A further common example is rogue individuals stealing data, for example, to take a client list to a new job. That is difficult to guard against if access to such data is part of their role, but you need to be aware of this risk nonetheless. For example, you could implement forensic reviews of IT activity both before and after someone hands in notice to leave employment. A data breach log should also be kept to ensure that you have a record of any such instance, and you can look for common themes which might identify technical or training needs. But as I say, appropriate technical and organisational measures doesn't just apply pre-breach, it also applies to breach response planning. And what we're talking about here are the proactive steps taken to put in place relevant plans and procedures to respond adequately to a data breach. So staff training to recognise and report a breach is a primary step, but there then needs to be a dedicated team and specific plans and procedures in place to respond properly to the breach in accordance with your regulatory obligations. This will include different steps for different categories of breaches, but will also include external experts who should or could be engaged or contacted following an incident. By that I mean lawyers, IT experts, cybersecurity experts, and potentially even PR experts, depending on the nature of the breach. Having an agreed panel will help you respond quickly to maximise the chance of reducing any risk of data subjects, rather than searching around for experts in the 72-hour period following the discovery of a breach. As David will touch on, that 72 hours really needs to be reserved for the investigation into the breach. And in circumstances where you have potentially lost access to computer systems, for example, following a ransomware attack, it will be significantly more difficult to instruct new experts who you haven't previously engaged with. The exact response plan will be different for each organisation and for each level of incident, but it is absolutely necessary to have an overarching plan in place. Ashford's have a panel of experts that we can utilise in response to a breach, but it is still prudent for firms to consider their own agreed panel in advance as part of their respective response plans. And again, the key point is if you do not have an adequate response plan in place and therefore fail to respond adequately to a breach, that could result in a fine from the ICO and or an increased damages claim from an affected data subject. And again, a key point is once a plan is in place, it should be reviewed regularly and tested regularly to ensure people know how to implement it and that it is appropriate. I will now hand over to David to take you through the steps in respect to a response.
Thanks, Tom. As Tom's alluded to, a data breach, as people on the call may know, is often quite a hot incident. It's always really helpful to have a predefined, clear checklist of actions to undertake to know exactly what you need to do following a breach. In a nutshell, they're the points on screen at the moment: identify, investigate, get some experts to assist if needed, think about your notification requirements, anything you might need to do under your insurance and existing contracts. Do you need to notify people affected by the breach? What can you do to mitigate any consequences? And do you need to notify action fraud and the NCSC? Just moving the slide on, thank you. So firstly, obviously, what is a data breach? As most people probably know, GDPR bites only on personal data, which is effectively data by which a living individual can be recognised, or information regarding their personal characteristics. And a data breach is when that data is exposed, destroyed, lost, altered, accessed, or processed in a way that's not intended. And so immediately after a data breach, what's the first things that need to be thought about? I mean, it's always going to be about early detection. Many breaches go undetected for weeks or months. We need to think about unusual activity. So I'm trying to tap back on the slide here. Thank you. Unusual activity being carried out by various threat actors. So unusual on a network, or unauthorized data being accessed, or things like ransomware or phishing incidents. So it's always helpful to be aware of information messages sent to employees. Common causes of data breaches that we see are often human error, as Tom's alluded to, things like missent emails, misconfigured systems, insufficient security patching is relatively common as well. It's also insider threats, things like disgruntled employees, social engineering. There was a case a few years ago involving Morrison's and a data breach caused by an insider, as well as obviously external attacks from threat actors, hackers, ransomware, cyber criminals, the usual kind of issues. So what do you need to do following a data breach is one of the key questions we get asked. Obviously, you want to work out what data was accessed, personal, financial, sensitive credit card details, HR records, customer files, supplier information, what data's been affected, what are we working with, who's affected, employees, customers, suppliers, third parties, maybe potential customers. That's always a bit more complex when there's individuals with whom there's no clear relationship between the entity that's involving the entity that suffered the breach. And how did this happen? Was it a lost device, maybe internal error, a cyber attack, ransomware? How did the breach occur? We'd always think about containment, isolating affected systems, revoking or suspending compromised security credentials, applying patches and backups. Commonly, as Tom alluded to, there's a panel or framework of third-party IT providers we'd operate and interact with here to deal with any particular issues regarding IT or technical information that needed to be addressed. So we've worked out hopefully what's happened. We've done our immediate shutdown. The next query that needs to be addressed or thought about is notifying the ICO. GDPR says that this needs to a data controller needs to notify the ICO within 72 hours of becoming aware of a data breach, unless the breach is unlikely to result in a risk to the rights and freedoms of people. If that notification isn't given within 72 hours, you need to give your reason, your excuses. It requires particular information as well, the kind of where, what, how, in terms of what data's been affected, how was it compromised, what's known about the incident so far, issues to that effect. And if it's not possible to provide that information up front, then it's possible to simply give an interim or initial notification to the ICO and saying that we'll provide more information to you as we become aware. As Tom's alluded to, though, any breaches that don't meet the requirements of reporting to the ICO still need to be recorded in your internal data log. Then the risk to the rights and freedoms, there's an assessment which the ICO can assist with here. Then the question then is communication to the data subjects. The threshold for reporting to individuals affected by a breach is higher than the requirement to report to the ICO. This typically is where things start to get a bit more complex in a data breach, where depending on the numbers, the amount of individuals that needs to be dealt with or spoken to becomes quite relevant. So the notice should include to them the nature of the breach, what's happened, the potential risks. As a rule, the threshold is high risk of harm, so things like financial fraud, identity theft. Any steps they might want to take, maybe reset their passwords, be aware of suspicious transactions on bank accounts, fraud, credit monitoring, as well as contact details for further information. Typically, that would be the DPO of any organisation that's suffered a breach. One of the key things we do is help our clients mitigate and triage those responses, where affected individuals are coming back or responding to that initial notification, the kind of queries, issues they're raising, threats, potential claims, complaints. Will help our clients through all that. This slide sets out the kind of exemptions, I suppose, from those respond to individuals. It's where the information that's been accessed as part of the breach is maybe encrypted. Maybe we've taken subsequent measures to ensure that that high risk isn't going to come into force, and it would involve disproportionate effort. In which case, things like public communications, so statements on websites or on occasion, adverts in national newspapers can be used as long as the end result is equally effective. Worth noting, though, that the ICO is only just starting to flex its powers that it's been granted under GDPR. It can do a lot more than issue fines and investigate. It can compel data controllers to do certain things, including inform data subjects, and the extreme version of the ICO's enforcement would be forbidding a business from dealing with data in the entirety around. Then rectification. So we thought about the breach. We've informed the people we need to in terms of the ICO data subjects, our insurers, our contracting counterparties, What do we do now? So the issues here are things like resetting compromised credentials, re-establishing security and ownership of the IT estate, enabling multi-factor authentication to make sure that people logging in are legitimate users, working with credit monitoring agencies maybe to monitor fraud risks for people affected by the breach. And then long-term fixes typically are behavioral in an organization. I think the statistics, something like 90+% of breaches are caused by someone's behavior. So long-term fixes would include things like security audits, improved staff training on cybersecurity, things like phishing, cyber hygiene, suspicious, malicious emails, those kind of issues. Think about data retention and access control policies as well. And then finally, I think this is back to Tom.
Thank you, David. And yes, just on the last slide, there's one other point to consider in terms of rectification, which is getting the data back in injunctions. It's a more common tactic that we see in the event of data breaches. Often, if you can identify those third-party individuals who've taken the data and it's not willingly given back, then you should consider taking injunctive action. There's also been a trend of late of injunctions being obtained against persons unknown following data breaches and cyber attacks. I do query the effectiveness of that, where the individuals are, overseas individuals who are not going to be fazed by a court order, given the activities they've likely just undertaken. But it is something that should be considered and taken forward if necessary, or if there's going to be real benefit in terms of obtaining and preventing the further dissemination of data. Now, turning to cyber insurance, this is kind of the final point that David and I wanted to touch on, as this is a kind of additional level of cyber protection that should be considered, and it's also something that really assists when a data breach does occur. But the key point to consider in relation to cyber insurance is it isn't just responsive in nature, but it will also focus on preventative measures such as testing and minimum security standards. So if you take out or seek to take out cyber insurance in the current market, there will be cybersecurity requirements which you'll have to meet, and you will be expected to implement certain steps before insurance's cover is actually conferred. So as well as providing that response package in the event of a breach, it will assist you in ensuring that you reach the required level of security standards. Typically, cyber insurance will also have a response hotline and a panel of legal and cyber experts to rely on, as well as coverage for legal and other fees, such as defending claims brought by affected data subjects, or potentially even pursuing claims against third parties responsible. Previous hurdle to obtaining cyber insurance was cost, but premiums are, so I'm told by insurance brokers, coming down. We do, however, come across a lot of clients who decide to take out cyber insurance after suffering a breach, and that will naturally increase premiums, make it more difficult to take out insurance, and it's self-evidently just too late. Our advice is very much, if you are considering cyber insurance, is not to delay. If you do have cyber insurance already in place, then that's fantastic, and you can opt to go through the kind of response hotline offered by your cyber insurer. But if it's equally that initial 72 hours, cyber insurance or cyber insurers have a lot more leeway in terms of how you respond and notify them. So typically, subject to what the individual policies say, you only have to notify within that first 72 hours, and you can take steps yourselves within that time period without having to notify if you feel that it's not necessary or doesn't require, given the nature of the breach in question. Obviously, some instances will require immediate notification. But again, we can kind of help advise on coverage and notification requirements as necessary in the event of a cyber attack or data breach. So actually, that brings us to the end of the webinar. I had said earlier I didn't think we would really have any time for questions, and I'm not sure that our format necessarily allows us to take questions, but thank you for listening. We hope it was helpful as a kind of high level run through of what to do in the event of a data breach. So do please contact us direct if you have any kind of follow-up questions or would like to discuss anything we said further. And thank you again for listening in.
Thanks all.